Well, good evening, everybody. I'm Hazel Genn, Dean of the UCL Faculty of Laws. I would say it's a great delight to welcome you to this evening. I have to say that it's probably trite and unnecessary to say that we're living in extraordinary times. I think that the size and distinction of the audience this evening is an indication of the appetite that there is for opportunities to discuss the issues flowing from the result of the referendum on our membership of the European Union. I think we've all been slightly taken by surprise at the speed of events, the level of uncertainty that there is over a range of issues, and of course the lack of precedent. All of this raises serious political, constitutional and fine legal questions. It's the role of universities to provide an arena for debate and for experts within universities to engage the public on the legal issues flowing from the referendum decision. We're fortunate to have outstanding expertise in UCL laws, in constitutional law, in EU law and in human rights law and a range of other laws as well. We want to be at the forefront of debate. We want to be informing the public about the legal parameters of Brexit, about what can and can't be done. We want to inform people about the range of views and to provide a forum for debating all of the various strongly held views on all sides. As I said, we've got outstanding expertise in UCL laws, in constitutional law and EU law. We want to be at the forefront of debate. And I am proud to be leading an expert team from the faculty. I think that they've provided a really rapid response to these issues. We want to make a continuing contribution to the debate in the future, and I'm hoping that this will be the first in a series of events where we continue to talk about these issues. I should say that this event this evening is supported by the Faculty of Laws, but it's also supported by the UCL Global Engagement Office. And I need to stress here, whatever the current context, that UCL is intensifying its global and European engagement. We're working harder than ever to implement our global engagement strategy following the EU referendum result. We will continue working collaboratively with partners across Europe and the rest of the world to achieve fair solutions to global challenges. And we want to stress that UCL remains an open, inclusive place to study and to work. Staff and students are offering each other warm friendship, collegiality and mutual support at what is a difficult time for lots of people within the university. I want now to introduce our chair for this evening, Joshua Rosenberg. Joshua is a long-standing friend of the faculty. He's a well-known broadcaster and newspaper commentator. He's a wise and expert facilitator of discussion, and he was recently appointed an honorary QC, which well qualifies him to chair this evening's discussion. I'm going to leave you in his capable hands now, and he will introduce the panel for this evening. Thank you, Joshua.
Good evening. Thank you very much, Hazel, and congratulations to UCL on organising the very first academic debate to be held since the appointment of a Prime Minister committed to taking the United Kingdom out of the European Union. There is, of course, tremendous interest in this subject. The 500 seats in this hall have been fully booked since last week, and the event is being live streamed and recorded for download in the future. Academic lawyers who understand the relationship between domestic law and EU law, far from finding themselves out of a job, are going to be more valuable than ever, and I'm absolutely delighted to say that we have half a dozen of them here. I shall begin by briefly introducing them in alphabetical order. Nearest to me, Professor Piet Ekhout, who is Professor of EU law, studied in Brussels, worked at the European Court of Justice in the chambers of Francis Jacobs, the Advocate General. He was then director of the Centre of European Law, what you might call another university, before joining UCL in 2012. Next to him is Dr. Tom Hickman, Reader in Public Law, also joined UCL in 2012. His research interests lie in public law, human rights, national security, constitutional law. He's a practicing barrister at Blackstone Chambers with a particular interest in the first topic that we shall be discussing tonight. Next to him is Professor Jeff King. His research interests include constitutional and administrative law, human rights, socio-legal studies. international human rights law. He's co-editor of the UK Constitutional Law blog and treasurer of the UK Constitutional Law Association. Next to him is Professor George Letzes, Professor of the Philosophy of Law here. After taking his first degree in Athens, he came to UCL to take his PhD. He's currently co-director of the UCL Institute for Human Rights and co-editor of UCL's Quain Lecture Series in Jurisprudence. Next to him is Dr. Virginia Mantovalu, reader in human rights and labour law. She took her first degree in Athens before coming to London, where she's also a co-director of the Institute for Human Rights. Next to her is Dr. Ronan McRae, senior lecturer in EU law and constitutional law. He took his first degree in Dublin before coming to London. His research focuses on comparative constitutional law, EU law, public law, with a particular emphasis on fundamental rights and the relationship between law and religion in liberal democracies. Ladies and gentlemen, please welcome your panel. Now, we have half a dozen questions on the running order. These are the questions that we listed for you on the note that you'll have seen. I'm going to take one or two together, and I'm going to take them in a slightly different order. And we have quite a lot to get through in the hour and a half that we have available, but let's see how we do. I wanted to conduct this discussion in a fairly free way, which means that members of the panel can chip in, contradict one another. It's just possible that if there is somebody here who knows more than the panel that you might catch my eye, but if you don't, we will try and have a round of questions towards the end. The question, I'll give you the 6 questions before we start, just so you know the order. We're going to start with the Brexit process, and I'm going to ask in particular what role Parliament should have, and the specific question of whether Parliament needs to pass legislation before Article 50 is triggered. And I think that is actually going to take us a substantial portion of our time, because I think that's a very big and important question. I then want to move on to the options for future relations with the EU. What model the United Kingdom might go for, and what are the advantages and disadvantages of that. Once we've told the British government what to do on that, we will tell it how to negotiate. Can and should there be exit negotiations with the EU before triggering Article 50? Is it possible? Is it desirable? Then after that, what about the options after Article 50 has been triggered? Can the notice of withdrawal be withdrawn, or is that a risk that it's not wise for the government to take? What about non-negotiable issues? The role of EU citizens living in the EU, in the UK, and UK citizens living in the rest of the EU. Can they be assured of being able to keep their residence? And then, just we'll deal with the minor and trivial issue of devolution, Scotland, Northern Ireland, even Wales, and so on. So I dare say we will actually have plenty of things to talk about. Our starting point is Article 50, which I've already mentioned. I'm only going to read you the first sentence of that, Article 50 of the Treaty on European Union. This says, any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. And so our first question, of course, is what are those constitutional requirements? In particular, is parliamentary approval required? I'm going to start with Tom Hickman, who was one of the authors of a highly influential paper on the subject, which came out straight after the referendum vote on the Monday morning. Then I'll turn to Jeff King, who was another of the authors. If the third author, Nick Barber, from, again, another university, not even in London, is in the audience, and maybe he can mediate, but I'm not expecting him to do so. There is an interesting factor, which is that, as many of you know, there is litigation planned and indeed underway. There is, I believe, a directions hearing next Tuesday. I think that Tom Tom Hickman is instructed in one of the possible cases, and that means professionally he can't speak about it, but that doesn't stop the rest of us from doing so. The problem with the layout of this room is that the panel are sitting down. That means that you may not be able to see them. I want to keep them over there because it means it's easier to discuss. I think some of them are going to stand up because it's easier then for you to see them, but I'm also going to ask them to hold the microphones close so that you'll be able to hear them, which is even more important. And I'm going to start with Tom Hickman. Tom, the question for you then is, what role should Parliament have in the Brexit process? Is legislation needed before Article 50 is triggered?
Thank you very much, Joshua. I'm just going to see whether that microphone works, or do I need to pick it up?
At the back, can you hear all right at the back?
Works.
Okay, you can hear.
I've got lots of thumbs up, so that's a good sign.
Off you go.
Okay, I'm going to start by asking you all to cast your minds back to the happy, tranquil days before the Brexit referendum. Indeed, let's go further than that. Imagine there was never even going to be a referendum. No referendum had been promised or organised. But then imagine this. Following a Conservative Party leadership contest, David Cameron was unseated. Liam Fox or Ian Duncan Smith or Bojo had become the party leader and Prime Minister. They won their victory from the support largely of deeply Eurosceptic members of the party. And one morning, intoxicated by their new powerful position, they decided to write a letter to the Council of the European Union, notifying the Council of the European Union of the Prime Minister's decision to withdraw from the European Union. Article 50 would be triggered. That, at least, is the position that the UK government has taken, as I will come on to explain. My question is, and the question we addressed in our blog, would that be a lawful act? Would that letter of notification be lawful as a matter of UK constitutional law? In the blog that we wrote, myself, Jeff King and Nick Barber of Oxford University, we argued, I can say the name, we argued that it would be an unlawful act because it would pull the rug from under all of our EU rights, and it would cut across the object and the purpose of the 1972 Act, the purpose of which was to give effect to the enlargement of the European Union and give effect to UK membership. Of course, the blog was not written in the context of a wholly unilateral act following Bojo's rise to power after David Cameron was unseated. It was written a day or two after the referendum result. But as a matter of law, does that make any difference at all? The European Union Referendum Act 2015 stated that a referendum shall be held. It did not say what the consequences would be of any particular result. It was expressly said in Parliament to be an advisory referendum. Contrast the Parliamentary Voting Systems and Constituency Act, the Referendum Act, we all went on proportional representation and so forth. And that Act specified that if the result was as specified in the Act, then the Prime Minister had to bring into effect certain legal provisions which were set out in a schedule to the Act. There's nothing in the Referendum Act, the European Union Referendum Act, that said if the result is more than 50% of people who vote wanting to leave the European Union, then the Prime Minister shall notify the European Union Council of the UK's decision that it wishes to withdraw from the European Union.
Tom, can I interrupt you with a question there? This proposal that the Prime Minister would simply write a letter to the Council of the European Union, would that be in accordance with the United Kingdom's constitutional requirements?
Okay, so we argued that it would not be. The power that the Prime Minister would use to write such a letter is what's called the prerogative power. That is, in a sense, the inherent power, the residual power that lies with the government of this country, inherited from the Crown, to do certain things in the national interest, one of which is to conduct foreign relations, negotiate treaties, and so forth. And we pointed to two legal principles that we argued show that you cannot use the prerogative power to unilaterally withdraw from the European Union. The first principle is that government cannot exercise prerogative power in a way which is inconsistent with a statutory provision. And as I've already explained, our analysis is that the European Union Act is intended to give effect to the enlargement of the European Union by the UK's membership. The second principle we identified is the principle that prerogative power cannot be used to take away legal rights. On the basis of those principles, we posited that the Prime Minister could not lawfully trigger Article 50 without an Act of Parliament authorising him to do so. It doesn't really matter a great deal what form such Act of Parliament takes. We suggested that it could be a very short Act of Parliament that simply said the Prime Minister shall notify the Council of the European Union of the UK's intention to withdraw. It does, however, have to be an Act of Parliament because the argument that I've just outlined and that we set out in more detail in our blog is that the exercise of prerogative power would cut across the 1972 Act. It would run against the grain, would be inconsistent with the object and purpose of that Act. Now that Act, the 72 Act, is an Act of Parliament. It is primary legislation. It is supreme law under our Constitution. So only another Act of Parliament could provide supervening authorisation to act in a way which cuts across that Act.
Tom, I want to bring in Jeff, and unless there's another short point you want to make before I get Jeff to respond to that.
Could I just make in conclusion a couple of just very short points? The points are these. They're both directed at the same question. The question is, well, what is the importance of this analysis? And the other thing that we sought to explain in our blog was that Article 50 of the treaty has two particular features. The first is that when you trigger Article 50, you're committing the country to withdrawing from the EU. And there's a 2-year guillotine. So if a withdrawal agreement is not negotiated within 2 years, then you are evicted from the European Union. Now that can be extended, but only with unanimous agreement. The effect of that is that, of course, it tips the balance of negotiating power, balance of power in the negotiations, massively in favour of the remaining states, because the exiting state cannot tolerate a position where it might be left evicted from the European Union without an exit deal. The second important feature, and I'll finish in just a second, of Article 50 is that once a member state has decided to withdraw, there is an obligation under Article 50 to notify the European Council. So if the referendum itself was a decision of this country to withdraw, then we would already be under an obligation to notify. If the exercise of prerogative by the Prime Minister is a decision of this country, then I imagine the government would come under great pressure to notify. On our analysis, as we explained in our blog, it's Parliament that has to make the decision to notify. And therefore, until Parliament does so, there is no obligation on this country to notify the European Council. That's where I will
Good.
leave
All
it.
right. Thank you. That's very, very clear. I mean, there are two important points that you made there. First of all, that it's inconsistent with the statutory provisions to use the prerogative powers, these executive powers, and therefore the prerogative doesn't apply, and prerogative powers can't be used to take away constitutional rights. Now, Jeff, you're in the interesting position of having supported Tom in the paper, but you're going to at least put, if not demolish, the counter-arguments now.
Well, thank you. I have three really important points I'd like to make, but only time for two of them. So both of them will be addressing important counter-arguments to the position that Tom has just put. The first one I want to address is very important, but I don't think it's very deep. And the point is this: there's something illegitimate about the argument that's being presented in this blog post, something illegitimate about saying we can't proceed without an act of Parliament. The illegitimacy claim is that this is an example of elitist lawyers unwilling to accept the results of the referendum. It's sour grapes. My only reply to that point is that the argument that Tom has just presented is not about whether the UK as a whole, including the Parliament, ought to carry through with Brexit. It's not at all about that point. It was deliberately excluded from drafting that point. The point was about how this proceeds, and how is extremely important here, because on the 23rd of June, the population voted on the whether question, not on the how question. So the illegitimacy argument doesn't fly, at least not against the case that we've made for the involvement of Parliament. Now there's a second objection to the argument that's just been made that is deeper and more sophisticated and is accepted by a number of distinguished constitutional writers. And the objection is essentially this: the European Communities Act of 1972 and the royal prerogative power of treaty making operate on two completely distinct planes. There's no conflict between the two of these. Now, this is an argument made by Professor Mark Elliott, a distinguished constitutional lawyer from the University of Cambridge, an advisor to the Lords Constitution Committee. As I understand it, it is adopted in Parliament by Lord Norton, also I believe by Lord Lisvane. So this is an argument with legs. It's sophisticated. But unfortunately, I don't quite agree with it. I don't know whether Tom does. I don't think he does either. Let me put the argument as fairly as I can before giving you what is our reply to it. Now, Mark Elliott kindly accepts that our reading of the Fire Brigade's union case is fair. It's something a court might buy. His argument is that they ought not to. And here's why. The European Communities Act makes provision for EU treaty law to be applied directly in the UK from time to time. The Act, he says, envisages that the nature of the treaties will change over time. And for that reason, if it's decided that EU treaty law should no longer be applied to the UK at the foreign affairs level, it does not in any way challenge the ongoing force of that Act. The Act simply bites upon, or is parasitic upon, is a legal conduit for the existence of these treaties abroad. And I'll quote him here: "If EU treaties were no longer to require EU law to have effect in the UK, because the UK was no longer a party to them, that would therefore not amount to a frustration of the purpose of the European Communities Act." This is an influential position, and not without support from many distinguished commentators. But what do we make of that argument? Let's start with a last comment. The long title of the 1972 Act is an act to make provision in connection with the enlargement of the European Union by including the United Kingdom. So the question is this: would a prerogative act that shrinks the European Union and excludes the United Kingdom not cut across that purported exercise of power? Would they not be incompatible? It certainly looks that way. If you look further in the Act, you'll see that the heading of Section 2 says general implementation of treaties. Section 3 makes provision for the inclusion in the common agricultural policy. Read as a whole, the Act cannot plausibly be interpreted as anything other than making provision for ongoing membership. But let me focus these claims into some affirmative propositions for why I think this argument doesn't succeed. The claim is this: the Article 50 process will either presumptively or necessarily lead to one of three outcomes with the European Communities Act 1972. The first outcome would be that it has to be amended, the second that it must be repealed, or the third that it becomes a dead letter and it does nothing at all. All three of those outcomes are contrary to the scheme of the European Communities Act. Let me illustrate briefly why that's what we could expect to have happened. Now, let's say we wanted to use the 1972 Act to continue to apply a rump of post-Brexit EU law. What would we have to do for that to happen? You see, the European Communities Act defines what the treaties are under Section 1, and it provides for many of the treaties that the Treaty of Lisbon and the Maastricht Treaty and so on to apply to the UK. To remove any of those from that list, you need to use a legislative amendment. Article 50 starts a process that can only end in two outcomes. Either you get a withdrawal agreement or the 2-year period expires and the treaties cease to apply. What's important here is that the treaties cease to apply in both cases, whether you get a withdrawal agreement or not. You need to amend that list under Section 1 in order to use it as a vehicle to continue to transpose EU treaty law into UK law. That can only be done by legislation.
But Jeff, just to interrupt you on this point here, obviously there will be legislation at the end of the process. Mm-hmm. The government's view is there doesn't need to be legislation at the beginning of the process. The government's view is that it can use these prerogative powers. Obviously this will be debated in Parliament. I suppose there may be a resolution in the House of Commons if that's needed, but there will have to be the support of the Commons. The Prime Minister needs the confidence of Parliament, and the view of the last government's legal advisers is very clear. These prerogative powers can be used to trigger Article 50, even if legislation is needed at the end of the day.
Any purported exercise of prerogative power that results in a necessary amendment, repeal, or dead letter of an Act of Parliament is unlawful.
May I now bring in George on this point? Had you finished the broad point that you wanted to make there, or?
Well, I'll finish briefly with the other two alternatives. The second is that repeal of the 1972 Act. That's exactly what is envisaged by Parliament, because you cannot shoehorn a post-Brexit agreement into an act whose purpose was to enlarge the EU. The last point is that if you do neither of those two things, and you merely left the act on the statute books, it would have no domestic legal force. That's patently contrary to the central holding in the Fire Brigades Union case. Thank you.
Thanks very much. I'll bring in George Letzers here. Either you or the others, I will put the question to, which is the question that I think a lot of people are thinking about, which is how is this going to play out in the real world? How is this going to play out in the domestic courts? But I know you've got some. I know you want to raise a prior issue, so please go ahead.
Tom, thank you, Josh. Tom and Jeff addressed the how. So the Constitution speaks to the how, but the argument doesn't speak to the whether. And the widespread view after the referendum is that technically it was not binding on Parliament. There's a textual argument for this. The EU Referendum Act doesn't say what the effect of the result would be. But the widespread view is that politically this is imperative. So this is going to happen. And I want to raise some doubt about that argument. And to me, it would be odd to say that the Constitution of this country and of any country is silent post-referendum on the whether. And I think we moved too quickly. Everybody, or most people, have moved too quickly from the result of the referendum to the argument that politically democracy now is a decisive reason on the whether. And I want to invite all of you here not to make that jump from referendum to democracy, because there's no inherent link between referendums and democracy. Democracy is a substantive value. It's far more than majority rule. And referendums are democratic insofar as they meet conditions that are themselves democratic. Scholars have highlighted those conditions. It's protection of rights of individuals against the tyranny of the majority. It's proper deliberation. But it's also the nature of the question. Now, as a constitutional theorist, the EU referendum, in my view, did a very poor job in meeting those conditions. I won't talk about deliberation and the climate of misinformation, but I want to talk about the other two elements. Protection of minority rights and individual rights, and the nature of the question. It strikes me that the demos, the people who decided the referendum, excluded people who should have had the say on this. And these are people who are EU citizens from other EU countries living here, whose rights would be affected by the outcome. Unlike the Scottish referendum, residents from other EU countries who live here didn't have the right to vote. So from the get-go, you have a problem in terms of the composition, who gets to vote, who gets to have an equal say. But more importantly, in my view, the nature of the question is a problem here. What we're having here is an effect on the constitution of the UK, which has been developed in the last 40 years. EU law has had a major impact on UK law. In the landmark Thoburn judgment of the Court of Appeal, Lord Justice Laws labeled the ECA Act as a constitutional statute. And the thing about the referendum is we are anticipating, or we are contemplating, an effect on a constitutional statute by having a one-off, in or out, binary logic referendum, which doesn't look at the effects this will have on the rest of UK law and a number of important issues of principle and policy, devolution, individual rights, and so on. So we asked the people to decide on a single issue. And the condition for the referendum to be democratic is that this issue is self-standing. To join the EU, to be a federal country, to have a system of electoral process. The decision to leave the EU is not self-standing. It has repercussions everywhere. So from the point of view of legitimacy, you cannot expect the people to decide this for good. So Parliament still has a constitutional duty at any given time to decide whether this is in the best interest of the country, because of the defects in the constitutional design of the referendum itself. I want to finish on this point, Josh. Referendums are not meant to replace democracy, they're meant to complement representative democracy. Right? They're not meant to replace representative democracy. And that's the kind of system we have here. They're meant to complement it. To do so, they have to meet conditions of democratic governance. This one was very deficient. So in my view, there's a the constitution speaks to the MPs. It tells them, the referendum is very important, but there's more to referendums, there's more to democracy than referendums, and you still have a constitutional duty to make your judgment about whether Brexit, given the implication, is still in the interest of the country.
Okay, now let me accept what you're saying for the purposes of argument. Let us accept that the referendum asked the wrong question, and let us accept that a lot of people think that the referendum gave the wrong answer. What is interesting to me is that in Parliament, everybody from the Prime Minister Theresa May downwards that I can see has decided that politically they have to accept the result of the referendum, reluctant though they are, and they've changed their positions as far as I can tell. If my assumption is right, then even if your argument, Tom, that legislation is required, even if that argument is true, then that legislation would certainly pass through the House of Commons, and I dare say it wouldn't be resisted by the House of Lords. But that's speculation. Let me take you back to the legal issues, and in particular, let me ask you whether you think the judges are going to be influenced by the popular will as expressed by the referendum. Because if I'm right in saying that MPs have said, we didn't want to do this, we don't want to do this, we think we've got to do this, because otherwise it won't be democratic, or otherwise it'll lead to rioting on the streets, or otherwise we'll lose our seats, or whatever reason, don't you think that the judges are going to be very reluctant to accept the arguments, sound constitutionally though they may be, shrewd, logical, and respectable, but they're just not going to work in the courts because the judges are not going to be seen to be standing up against the will of the people? Who wants to? Pete, do you want to respond to that?
Well, yes. I mean, it's not for me to make any predictions, sociological predictions about the attitude of UK judges as an EU lawyer. But I have felt ever since the referendum result was released that we are and we continue to live in a kind of parallel universes. On the one hand, there's the political universe where the whole of Europe and all of the political class in this country considers that the decision on Brexit has been taken. And on the other hand, you've got the legal and constitutional universe where I fail to see where and who that decision was in effect taken. As an EU lawyer, I start looking at Article 50 from the top down, as you indicated, paragraph 1, and I've always felt that we were at risk of not seeing the elephant in the room. Now at UCL we're good at seeing elephants in the room, and I think the debate's already clarified that a little bit. The issue is not so much as to who can notify. Notification is is a consequence of a decision to withdraw in accordance with your constitutional requirements. Now, either Parliament has decided when it adopted the Referendum Act that it would definitely follow the referendum result, but it has not done that. It's been declared as advisory. The government, to my knowledge, as a formal government decision, has not yet decided to withdraw. And members of Parliament may well be expressing the view that we have to follow the will of the people, but the Parliament as such has not adopted a decision. So, and I think in terms of what the judges could be asked to do, it would, and I would echo what I think Tom and Jeff have been saying, it would be simply a decision on whether it is in the power of the government of this country to take that decision, which has not been taken yet, or whether it's in the power of Parliament, and through what mechanism Parliament could adopt that decision.
Thank you. I want to put this point to Ronan, if I may, because these are constitutional law points. And I want to put to you 2 points with which you'll be very familiar. The first is that the courts are very reluctant to intrude on matters of parliamentary privilege, and very reluctant to tell Parliament whether it needs a resolution, whether it needs an Act of Parliament, what it needs to do. And secondly, and perhaps a stronger point, they're very reluctant to get involved in hypothetical questions. They're very reluctant, the courts, to give advice to anybody, let alone the government. And the question being asked of them at this hearing, if it goes ahead, is whether the law requires an Act of Parliament or not. The courts are surely going to say, well, you, Prime Minister, do what you think is right, and we, the courts, will tell you after the event whether it was lawful or not.
Yeah.
What do you say to that, Ren?
Well, there's 2 problems to that. The first problem, I suppose, what George is saying is that coming from a country with a long history of European referendums, there probably isn't. You would never have had one if you'd had the experience of them. However, all the European referendums in Ireland can be criticised almost on that basis too. It's extraordinarily unlikely, I think, that the courts would intervene. I mean, whether they should or not, but they would. The second thing is with your reverse is that once, what we're forgetting is that the matter of notification under Article 50 is an EU law question. So once notification is given, that's valid as a matter of EU law, and they're not interested in UK constitutional law, the clock starts ticking. So because the EU will not generally look behind the credentials of government ministers who commit their governments to do things in the EU, it would definitely be too late if the courts adopted that process. Once notification is given, it's valid as a matter of EU law, the EU law clock starts ticking, and that's the clock that counts.
So what you're saying is it's going to be too late after the event.
Yeah.
What I'm saying is it's too early before the event. Virginia, I want to come to you because you haven't had a word yet. If this is a question of EU law, if this is a question of interpretation of Article 50, maybe it needs to go to the Luxembourg court. Do you want to comment on that, or do you want to comment on this broader question of whether you think an Act of Parliament is required? And then I'll come back to the 2 speakers who've spoken before.
I mean, I don't have something to add to what the speakers have said on whether an act of parliament is required. I want to focus on whether there are any limits to the negotiations.
Okay,
for
well,
the
I can
government.
come back to you on that. But
Yeah.
let me, now, which of you is going to talk? All right, Tom, you spoke first. Respond to my attempts to make mischief.
Can I just respond to one point? I'm obviously not going to go anywhere near the invitation to speculate on what the courts may or may not do. But you did make one point about the blog, and I'm going to confine my comments, as I have thus far, to the blog and what we said in the blog. All we said in the blog is that an act of Parliament would be required. We didn't say at all that Parliament, it would be appropriate politically or constitutionally for Parliament to take a different view from that taken in the referendum. We said as a matter of strict law, Parliament could do that. There's no part of our argument. In fact, the argument that we developed was principally focused on the points that I have explained, which is the importance of the fact that no decision has been yet taken by the United Kingdom and that needs to be taken by Parliament. The value that Parliament can bring to the whole process because of its expertise and so forth, and the fact that it might lend some weight to the government's negotiating position, because we said in our blog Parliament is unlikely to send the government off to issue its notification when it has absolutely no idea what the outcome of the negotiations are going to be. At the moment, it doesn't even know what the government is going to be asking for, let alone what it might achieve. So it's not at all a question of this argument rubbing up against the referendum result. It doesn't at all do that.
Okay, and Jeff, you made that point that it's not sour grapes, but on the other hand, this would be seen, if not as an attempt to overturn the result of the referendum, certainly an attempt to delay giving notice under Article 50, because if these proceedings go up to the Supreme Court, they would normally take several months. It's perfectly possible for the courts to deal with them more quickly, although that tends to sometimes lead to error. And obviously, at this directions hearing next Tuesday, the court will ask the government whether it's in a hurry to get on with it, or whether it would quite like a few months' delay while it works out what it's going to do. But do you have any comment on the practicalities from that point of view?
Well, it's not part of our legal argument or even political argument that a delay is a positive thing, but it's a potentially happy consequence of the fact that we need to sort this out properly constitutionally. The delay doesn't just come from the litigation, but if you adopt an act of Parliament, that takes time as well, especially for a situation like this. Both of these can be justified to the European Union as complying with our domestic constitutional requirements in good faith.
It might well suit the government to be able to say that, well, we can't do anything for ages because it's going through the courts. So, we will see with great interest what the government says next week. I think I want to move on to question 2. And question 2 is, what are the options for future relations with the EU? What are the models, what are the ways in which we can, assuming that we go ahead with the will of the people and we accept the political realities, what are the options and what are the consequences for the UK? And Pete, I think you're going to start on this.
Thank you. It's not very easy to say a lot about that in 5 minutes, but as we were sort of preparing this discussion and debate, we were talking about sort of models which have a name of a country to them: the Canada model, the Norway model, the Turkey model. I don't think we mentioned the Albania model, which was favored at some point. Actually, my own thinking about this is that there really is only a choice between 3 options. One is to keep some kind of membership of the internal market. The other is to have some kind of free trade agreement with the European Union. And the third is to have neither of those and simply to trade with the European Union on WTO terms. Because all these different Norway, Switzerland, Turkey agreements are basically either participation in the internal market or a kind of trade agreement. And if you want to really simplify the choice between those two options. It is, I think, a choice between trading within one single market, which has not identical regulations, but harmonized regulations covering all goods and most services, versus trade between differently regulated markets, where basically the agreement is about the terms of trade and any sort of regulatory cooperation. So I think the essential problem of the choice between those two models is that the economically most attractive option, participation in the European Economic Area, so participation in the single market, is really inconsistent with two main themes of the Leave campaign. The first one, to take back control, and the second, focusing on immigration. In purely formal legal terms, it could be said that the EEA is a return to greater national sovereignty because there is no direct effect and primacy like we have in EU law of the same nature. But if you look at sovereignty as a substantive political concept, of course the EEA is much worse than EU membership, because you have very little opportunity to influence the decision-making, and you have an obligation to implement a very considerable amount still of EU law and legislation. For example, the free movement of workers, the free movement of persons is there, as we know, not EU citizenship, but in fact there is a citizenship directive, and that is currently also part of the EEA acquis. So it's much wider than just free trade in goods and services. And on the immigration side too, it's clear that it will be extremely difficult to introduce restrictions, as the EEA includes full free movement of persons. And the European Council at the end of June has formally said almost nothing about Brexit. It has noted the results of the referendum, and then the 27 have made a statement which doesn't say very much, except for the fact that they have said that access to the single market requires acceptance of all the 4 freedoms. So could there be any room for a compromise here? I think at most, and this is purely a political conjecture, it's not a legal argument, but at most I think the EU might perhaps discuss something like an emergency break on free movement in the context of the EEA, with upper limits which might be set at a level that the break would rarely be used. I'm not even sure that would be negotiable, but the EU is also facing a very similar problem in its relations with Switzerland, because Switzerland has also had a referendum on free movement, and by next year the government in Switzerland needs to implement that referendum, so that also undermines the agreements with Switzerland. Conceivably the UK government in its negotiations might try to get something of that kind, but I think there would be a really big price to pay for it. I would add in that context that I don't think free movement is necessarily a binary all or nothing issue. The minute one moves away from the idea of imposing restrictions on numbers of people coming to this country, there are definitely very important questions with which the EU struggles generally, about finding the right balance between open borders on the one hand and domestic political responsibilities of the welfare state. And I don't think that European Union law has necessarily managed to achieve great coherence in this respect. The sort of canary in the coal mine, or the best indicator of this, is that any issues to do with residence conditions which a state may impose for the award of certain benefits or tax advantages or any other kinds of housing, for example. If you check EU law on that, it's very diverse, and it's not very coherent on whether and when a residence condition could be imposed. So I think there is scope for a lot of reform of EU policy in this respect, but of course a Brexit UK will not be in a very good position to achieve that reform compared to if the vote had been Remain. If membership of the EEA is not achievable, then we are left with a kind of the option of a deep free trade agreement. I think the only option which is really closer to than that of an arm's length WTO relationship. I've heard one commentator use the concept of a cross-channel trade and investment partnership. So that would be a CTIP as opposed to the TTIP with the United States. It's not a bad analogy, I think. And if anything, it's not a bad analogy because it draws attention to the political difficulties which the negotiation of such agreements attracts. If the UK first withdraws from the European Union, and we may have opportunity to say something about that because there are procedural issues also, I think, and with sort of how the Article 50 process works. But that's what Brussels is currently saying, that you first would need to withdraw from the European Union and then make an agreement on your future relationship. So if the UK first withdraws and only then starts a free trade negotiation with the EU, I would be very worried about the prospect of a speedy and successful process. International trade negotiations are not popular in Europe these days and no longer a technocratic affair which can be undertaken away from the political limelight. We've got the CETA with Canada, which is already looking precarious. The Commission has just announced that national parliaments will have to approve that, has conceded that. I think there is not too much hope for a conclusion of the TTIP negotiations. And there is a risk, I think, that as soon as the UK is out of the European Union, a CTIP negotiation meets a similar fate. Even if one could argue the UK's position is very different because it's an ex-member state and has in fact already been part of the internal market.
Peter,
so I think this course of action will require immense political leadership throughout Europe, and that's not a commodity which is in great supply at the moment.
Well, look, let me see if I can. Thank you very much, Pete. If I can sum up, the discussions around the new cabinet table. Presumably, it's a question of which is the priority. Is the priority to aim for sovereignty and restrict free movement of people, in which case you go in one direction? Is the priority to have something closer to the single market that we have at the moment, in which case you go to the other direction? And presumably that's what's going to be argued about around the cabinet table in the days, weeks and months ahead. Ronan, do you want to pick up on this?
Two small points about the precedents. First, I think we need to also be aware of the degree to which EU institutions perceive this. So this has been a very traumatic time for British politicians, but it's also an existential threat for EU institutions. But the existential threat for many of them comes from the idea of a generous agreement, because they are worried that a generous agreement to the UK will provoke a general unravelling of the union, because every member state has bits of the single market, bits of the union it hates. So one of the real difficulties of the British government is that a generous deal is dangerous to the EU and they won't want to give it. They may look for a fig leaf on free movement to allow the government some kind of break, emergency break, and there is precedent in EU law for that. It relates to one of the key rights of EU citizens is the right to vote in the European Parliament elections. Now, that's not a big deal for most people, but in the theology of EU law, it's quite a big thing. And Luxembourg has a derogation saying because over 20% of its population is EU citizens from other member states, they're allowed to impose a 5-year waiting period before you get those voting rights. So there is a precedent for some kind of emergency breaks in relation to fundamental EU rights. But an EU parliamentary election is once every 5 years. A lot of people don't really care about it. Free movement rights to live and work, impact on so many things and are every day. So it's really not a great precedent or a very promising one, I think. The final thing is that if the UK wants to get into the EEA as an option, they also have to get the consent of EEA member states as part. So that will also add a further complication. They probably give it, but it just shows Article 50 doesn't seem to recognise that, because I think Article 50 was drafted on the basis it would never be used. So.
Yeah, that may well be true. Well, then let's and the reason I took this question slightly out of sequence is I wanted to establish whether the advice to the government is to establish first what its priorities are, its political priorities, what it's seeking, what it's aiming for, before it decides whether to trigger Article 50. Because what you were saying, Pete, was that obviously if we put it off till later, it may be difficult. We're going to talk about the practicalities of Article 50 in a second, but are we agreed that the government needs a pretty good idea of where it's going before it even triggers Article 50, with or without an Act of Parliament, because the priority is to work out where we're going. Does anybody want to, Jeff, do you want to comment on that? Or?
Well, I think it would be madness to try to negotiate something as complicated as complete exit with no strategy or game plan in place. There must be a difference between seeing what options the other member states might be minded to engage in intensive negotiations, and that type of sounding out happening before triggering Article 50 would seem to me to be the appropriate way to begin this. I don't think that would necessarily fly in the face of the statement of other members that negotiations don't start until notification.
Well, let's explore that, because that, as you rightly say, we had all this bombast, perhaps that's a slightly pejorative term, we had these comments from the President of the European Commission, which said, right, that's it, you've decided to go, trigger Article 50 and off you go. And a slightly more emollient tone from Angela Merkel. The obvious thing, it seems to me, is for the British government to at least start with bilateral negotiations, to talk to individual governments, and Germany may be a good place to start, to at least discuss the outlines of the direction we're going in. You agree with that, Jeff?
I do. Quiet diplomacy even might be the way to do that.
George, do you want to comment on that?
Well, I was going to say that uncertainty, which will be the result of not having a plan to go to the negotiations with, is not only bad for markets, it's bad for people. So there has to be a clear sense of where the country is going to do by replacing or repealing the ECA Act and removing EU rules from the country. You cannot do that without having something to replace it with. So the process of negotiation has to have a plan in mind of what will replace the current scheme, of the extensive rights and liberties that EU law and the single market now gives to people. You can't just say, okay, we've decided to go, we have no plan what we want, let's negotiate. This has not only a negative impact on markets, but on people's rights and liberties. So that's very important. So I think that's definitely needed, not only as a political matter, but as a legal matter.
Virginia, do you want to comment on that?
Just a small point. I think it's already madness that there hasn't been a plan on all these issues already.
We've only had a Prime Minister for an hour, but you're right, no, it is ridiculous that the government didn't have a plan, and no doubt they're working on one now. One hopes. There must be a plan somewhere, and if not, they need an awful lot of lawyers to help them. I mean, Ronan, do you agree that the government's position must be we want to talk to other members of the EU before we trigger Article 50?
Well, I think that's definitely their position. I don't think they get very far, because you have to remember that Article 50 it's kind of the opposite of the Hotel California, because when you check out, you're definitely leaving. The clock starts ticking. So if you think the three key bits are, the clock starts ticking, 2 years to have an agreement, once notification is given. That agreement is done by qualified majority votes, or 55% of the states representing 65% of the population. So that's the majority that has to agree the departing deal, and the European Parliament has to approve it. And if there's no agreement, there's an abrupt divorce. The UK loses all its EU law rights and privileges and duties. So as you said, the EU member states are clear. They've said no negotiations. Why? Because they know that the abrupt divorce is much more disruptive for the UK than the EU. It's disruptive to the EU, but it's much more disruptive to the UK. So the UK's best hope is to try and peel off one or two states to get some bilateral agreements to kind of agree common positions before the clock starts. But the problem is the structure of Article 50 really is not going to help. So Ireland, which will be very badly affected by an abrupt divorce, might be sympathetic, but the structure of Article 50 doesn't help the UK because, as I said, the agreement to leave does not need to be unanimous. Only a qualified majority of states need to approve it. So that means that no individual EU state, and certainly not a small one like Ireland, can veto the deal. So that means even if Ireland wanted to help the UK, they're going to be, the Irish government or all the states will be dependent on the goodwill of the other states to ensure that the deal that is struck eventually with the UK covers their basic interests, their most important points. So that means each country is going to be going in with 3 points that they really want, and they'll be cooperative in everything else. So because it's not by unanimity, it's by qualified majority, there's very little incentive, even for states who would lose very heavily from an abrupt divorce between the UK and the EU, to help the UK by informally negotiating with them before Article 50, or to even push for a generous deal for the UK. Article 50 is structured to prevent that. It's actually structured, the way it's structured reinforces solidarity between the 27 at the expense of the UK. So I think they might want to negotiate beforehand, but they're not going to get very far.
I'm sorry about the alarm. I don't know what it means. Somebody's gone out to check. It's gone. There we are. I was glad we solved that. Pete, I want to ask you about the risks of triggering Article 50. As we've heard, once you check out, you can't check back in unless the other states agree, subject to what Ronan has said. Is that a risk that the government can ever afford to take?
Well, perhaps the first point to note is that there is somewhat of a debate about what the exact legal position is and whether it is possible for a member state which has notified that it seeks to withdraw from the European Union to withdraw that notification.
Article 50 is silent. It doesn't say.
It doesn't say anything. There are a number of experts, but we know, of course, that we cannot necessarily trust them. There are a number of experts who say that that should be possible. My own view is really that it's very, very difficult to see that as a correct legal answer, as a matter of sort of unilateral right of the United Kingdom to, at any point in this whole process, decide to reverse its decision. And I think the importance of that legal question is also very much linked to the question domestically here about the division of roles between the Parliament on the one hand and the government on the other hand. Because if you, I think in what Tom and Jeff have been arguing, it is implicit that once you set yourself on the course towards withdrawal from the European Union, you cannot on your own stop that course of action. I'm sure that if all member states were to agree that Mr. Legal, who is the director of the legal service of the Council, would find a solution with some protocol or some kind of European Council Act which decides to stop the clock and stop the withdrawal process. But in terms of whether the notification to Brussels has a definite effect on the European Community Act in this country, the question is really whether the UK government controls the process of stopping that notification or not. So I think there are, the text is silent. I mean, there's one element in the text, I think, which suggests that you cannot, because it says that if there is no withdrawal agreement, after 2 years, the clock stops ticking and you're out. So that suggests that those who drafted Article 50, I still need to find out who that was, that they had in mind really that there should be some kind of sanction, that the member state which is seeking to withdraw cannot sort of keep the European Union hostage for 10 or 20 years, and that 2 years stops that. But there are more fundamental arguments, I think. I mean, it would really, if you accept that any member state which has issues with its member state of the European Union could simply notify the European Council of its intention to withdraw and then start negotiating, and if it's happy with the negotiations, withdraw. If it's unhappy, withdraw the notification and remain a member state. That almost invites abuse of the process, and maybe at present we cannot see any other member state abusing that, but with current political times, one never knows, and this might change very quickly. Okay. So I think avoiding abuse, and we have a principle of loyal cooperation in European Union law. It seems to me that an interpretation of Article 50, which gives a unilateral right to the withdrawing member states to sort of at any time stop the withdrawal process, does not sit easily with that principle of loyal cooperation.
Okay, I want to move on now to the question about whether there are any non-negotiable issues during the negotiations and the position of EU citizens living in the UK and of UK citizens living in the EU. Virginia.
Yep. Thank you, Joshua. So I will focus on an issue that has not been particularly, well, it has not been discussed today, and it hasn't been discussed much in everything I've been reading the last 2 weeks, the legal aspects of it. And the issue is that we have heard lately that EU citizens, EU nationals, EU citizens from other countries outside the UK that are based in the UK can be used as bargaining chips in the negotiations. A few days ago, Theresa May said that she would not guarantee the rights of EU citizens in the UK. Later on, Philip Hammond said on Radio 4, I think, in an interview, that it would be unwise or absurd to guarantee the rights of EU citizens to stay in the country before the negotiations are completed. And then James Brokenshire, the junior Home Office Minister, he was prepared to be slightly more reassuring to EU citizens that are based here from other EU countries, and simply said that there will not be any immediate changes to their status. So they're not going to be deported immediately. So I want to argue that the position of the government may lead to violations of the European Convention on Human Rights. Article 8, the right to private life of the European Convention on Human Rights. Now, we know many of you here may have seen that the Leave campaign on its official leaflet sort of claimed that the European Union and the European Convention on Human Rights are the same thing, but of course, probably all of us know that they are not. So the referendum was not about the European Convention on Human Rights. We have not decided for the moment to withdraw from the European Convention on Human Rights, and in fact, Theresa May said that she guarantees now, for the near future, that we are not going to withdraw from the European Convention on Human Rights, so that's great news. That's how low the standard is. It's great news that we're not withdrawing from the European Convention on Human Rights. So right now there are about almost 3 million EU citizens from other EU countries, in addition to the UK nationals that are still EU citizens in the UK. They have arrived in the country lawfully under EU citizenship rights. They have exercised their EU citizenship rights of free movement, arrived here lawfully and built their lives here, started working, built relationships, friendships, families, etc. The problem is that in EU law that is still binding, you can deport EU citizens only if they pose serious threats to national security, for instance, so in extreme situations. But the government, Theresa May and others, do not want to use that EU law exception. They claim, we have to presume that from their statements, that their plan is to deport EU citizens from this country, even if they do not pose a threat to national security, if they are unhappy with the outcome of the negotiations. This is my understanding from the statements I've been reading. So I argue that this may breach European human rights law, the European Convention on Human Rights that is still binding. So it has, the argument has two aspects. First, I think that even the present uncertainty and the anxiety created to EU citizens who have arrived in the country with legitimate expectations, lawfully, with legitimate expectations to stay here, the uncertainty that is created with all the implications for the planning of their lives certainly gives rise to issues of Article 8, the right to have a family and private life under the European Convention on Human Rights. Second, any future deportations, which the government seems to leave open at the moment, will also may also well lead to violations of the right to family and private life. So the right to private life generally in the European Convention on Human Rights has a very broad, it's interpreted very broadly. It's not only about protection of what we do in the privacy of our homes. The European Court of Human Rights, for instance, has said that the protection of a particular lifestyle, a way of life, falls within the ambit of the right to private life. It established this in a line of cases on Roma rights, Romas that were evicted from their land. The European Court of Human Rights in this case, in this line of cases, said that a particular lifestyle is protected under the right to private life under the European Convention on Human Rights. In another line of case, particularly
So
for people...
I've got to sort of cut you off there before you talk about the other line of cases, but what you're saying in summary is that it would be possible to use Article 8 of the Human Rights Convention if the government decided to deport EU citizens once we leave the EU. You know, I very much hope that Theresa May isn't listening, because if she is, maybe she will then decide to go back on her policy that we would remain in the EU. But that's broadly your argument, isn't it? That you could actually bring a case to Strasbourg challenging the decision. Okay.
The decision to deport.
Yes.
Yeah, but not only. Yeah, certainly the decision to deport. I mean, there are. The fact that there are a lot of EU citizens from other European countries in this country that have also developed, have jobs and have careers and families. The uncertainty, not the deportation, but the uncertainty that is created right now, the inability that it creates to the planning of their lives. You know, I've heard people saying, will I register my kids to the nursery, or will we be kicked out in a couple of years, in a year or two? So the uncertainty and the anxiety created by this situation, this may lead to a violation of the European Convention.
And could you do anything before the government's made a decision? Could you have some preemptive strike, some preemptive application to Strasbourg, starting with our domestic courts and exhausting domestic remedies here?
At the moment, I don't think they have. But yeah,
it's possible. But,
yeah.
Okay. All right. Look, I want to leave it there because I want to just briefly talk about the constitutional dimensions of devolution, which I promised was the last question. So thank you very much for that, Virginia. Briefly, Ronan, if you wouldn't mind, about the constitutional dimension of devolution.
Okay, well, the Brexit referendum has brought two trends within UK constitutional law that have been developing for the last couple of years into kind of starker relief. So the first is the complications that arise from the dispersion of lawmaking authority throughout the UK by process of devolution. Now, theoretically, issues of EU law and relations with the EU are reserved to the Westminster Parliament. They're only for the Westminster Parliament. But EU law and EU membership is woven into the devolution settlement in a lot of ways. A lot of areas of policy that have been devolved, like agriculture, are actually substantially regulated by the EU. And also the devolution acts that establish, for instance, the Scottish Parliament, provide that laws by the devolved institutions that violate EU law are void. Now, so this means a decision to withdraw does bear on the devolution settlement. Now, the UK is unusual in that the term unconstitutional is not synonymous with illegal in the UK Constitution. It more means kind of rude, administratively rude. And that is very unusual, because normally for most countries, unconstitutional is super illegality, but not in the UK. And there is a constitutional convention that Westminster does not legislate in relation to the devolved institutions of their competence without their consent. And there has been talk that the Scottish Parliament could withhold its consent. However, it's not legally a runner, because legally, EU matters are for the Westminster Parliament. It would be possibly unconstitutional, possibly a breach of convention, possibly unconstitutional and rude, but it would not be illegal for Westminster to proceed with leaving the EU in the teeth of opposition, probably from the Scottish Parliament.
They don't have a veto.
They don't. But with a broader perspective, things are a bit more complicated, because one of the features of the last 40 years has been increased use of referendums. And in the last referendum, even this last referendum, the idea has become accepted that there are certain constitutional issues in relation to which the electorate via referendum is supreme over Parliament. Parliament is not the supreme constitutional authority. But the devolution process, which has involved sanctification by local referendum of the devolved institutions. So they have effectively established local sovereigns, the Scottish or Welsh electorate in referendum, who outrank Parliament, at least in terms of deciding questions of independence. We saw that in the Scottish referendum, where it was recognised, the UK authorities recognised that it was for the Scottish electorate alone to decide on Scotland's continued membership of the Union. And that's remarkable. In Canada, in 1999, they passed the Clarity Act, where the central government laid down quite strict conditions, including supermajorities and things like that, under which they would recognise a decision by Quebec to leave Canada. In the UK, the only control the Westminster authorities felt entitled to insist on was the clarity of the question. They said that Scotland could leave by a one-vote majority in a one-off referendum. Now that leaves the UK very far from being a kind of mainstream ideas of nation state, which involve a kind of degree of better or worse commitment. And actually the current Scottish government has said that a material change in the relationship between Scotland and the UK, such as Brexit, could trigger another referendum. And although the UK government has said there should not be one, they have not said that there could not be one. If the Scottish Parliament votes by a large majority to have a referendum, I suspect it will happen. Now that leaves Scotland's position in the UK remarkably similar to the position of the UK in the EU outlined in the 2011 European Union Act. In that act, Westminster said that any further transfer of powers to Brussels would have to be approved of by a referendum. Similarly, the Scottish Parliament is now saying any change in the relationship between Scotland and the rest of the UK, including Brexit, can trigger a referendum. So there's a real fundamental tension between the idea of a UK-wide referendum with a single UK majority binding the whole state and the recent trend to recognition of the effective sovereignty of the constituent units of the UK. The position is now, apparently, the UK may leave the EU by its own constitutional requirements, according to referendum, and each part of the UK can leave the United Kingdom by a majority vote in a local referendum. So the UK is leaving the EU, a federation of sovereign nation states, in the name of national self-government and parliamentary sovereignty, at the same time as it's finding out that it is now itself a mini-EU, a federation of sovereign nations that can leave, to use the EU's term, in accordance with their own constitutional requirements at any time. So I think it's a perplexing situation.
All right, Jeff, I'm going to ask you to get the government out of this minor problem. We know that Wales voted to leave, so let's talk briefly about Scotland and Northern Ireland, and then I may just have room for a round of questions.
Wonderful. I'll try to be as brief as I can. In Northern Ireland, the situation is that 56 voted to remain, 44% to leave. The DUP, which is the largest unionist party, campaigned for the one, and Sinn Féin campaigned for the other. You'll never guess which. Now, what is the constitutional significance of this disagreement that we're seeing? It's absolutely essential. The key to understanding government in Northern Ireland is that it's a consociational one, and that means it governs through cross-community support on any controversial legislative proposals. That cross-community support means that all members of the Northern Ireland Assembly, when they bring forward a consent that requires this, it can either be approved by parallel consent, that means a majority of both communities will need to support it, or by a qualified majority. That means 60% overall need to support it, with 40% from each community. This is central. It gives effect to the Belfast Agreement. It's a key part of the peace arrangements. The fact that this issue, Brexit, cuts across cross-community participation is very significant constitutionally and politically. This is in the context of an increasing polarization of political discourse in Belfast and throughout Northern Ireland. So the parties on the nationalist and unionist fringes have actually had increasing support since the consociational settlement was struck in the late 1990s. And here, there are enormous economic consequences at stake. So exports to Ireland constitute 30% of exports to the EU for Northern Ireland. Exports to the EU as a whole are 21% of its exports. So if we were to, that has enormous economic consequences. If we were to stem free movement between Northern Ireland and Ireland, then that could have politically, if not literally, explosive consequences. For a border between these two areas is extremely significant. Such was reported in The Independent last week. Another point is that The Northern Ireland Act, in the very first section, provides that if a majority of people in Northern Ireland wish to leave the United Kingdom, they can ask the government of the United Kingdom to make that happen. This disagreement will push, it is expected to push many Catholics who support ongoing union with the United Kingdom to switch allegiances. And since that population is expected to grow within a generation to outstrip the Protestant one, we may very well see that power under Section 1 be triggered, which could lead to the end of the United Kingdom of Great Britain and Northern Ireland.
Jeff, do you want to talk briefly about Scotland? Then?
Yes.
Yeah.
The point for Scotland is that the SNP made crystal clear in its manifesto that it would treat a leave vote as a trigger for a second referendum. Do they have the authority to call their own referendum legally? Probably not. Practically, it would be very difficult. The government of the UK made a statement to the Lords last week saying that in their view there should be no second referendum in Scotland, which I think means there won't be. This is setting us up for a massive game of political brinksmanship that may well lead, I think, to the dissolution of the Union. That's it.
Yeah, okay, on that minor detail. Is there a roving mic? Has somebody got a microphone? Yeah, okay. Why don't you, gentleman there, I'm going to take about 2 or 3 questions. Oops, sorry. I can take about 2 or 3 questions. Would you take the mic to the gentleman there in the corduroy jacket? The idea is the panel write down all the questions they hear, and they have a choice as to which they answer. They'll get one chance to answer. Go ahead, sir.
Christopher Ray, what is wrong with the, to me, natural reading of Article 50 in relation to the 2-year time limit, that it is there to protect the right of the would-be leaving party to implement its self-determination, namely that if the remaining states refuse to come to an agreement, then at the expiry of 2 years, that state that wishes to leave is able to go ahead with its leaving, agreement or no, and that is the correct and arguably only substantive purpose of that clause. It is not to compel departure if the state, before an agreement, chooses that it no longer wishes to leave.
Okay, so that's the reading of Article 50. Gentleman in the shirt and tie there, yeah, just that man. Yep, that's it. You, sir? Yeah, go ahead.
Thank you. I wanted to ask a question about the ramifications of the argument that Tom and Jeff are making about Article 50, if that's all right. There's a convention right to life, and we've got legislation that brings into our domestic system, I think, criminal offences of extreme atrocities, Geneva Conventions and so on. And I wonder what that means domestically for the prerogative power to do things like launch Trident. Are you saying that when Theresa May is writing the letters, she's probably writing at this very moment to submarine commanders, she should say, look, I'm sorry chaps, you can't launch these in any circumstances because I'd need an Act of Parliament?
Very good. So limits of the prerogative. Lady, just the lady there. That's it. Yep, go ahead.
Hello there. Thank you so much for such an engaging discussion so far. Does anyone realistically believe that it's possible to have Brexit and to continue the free trade and free movement between the Republic and the north of Ireland? There's talk about this common travel area that precedes our membership of the Union, the EU Union, I mean. So any thoughts on that? Thank you.
Okay. A gentleman here, I think, in the blue tie, quite close to me. Yeah, that's it. And then the man behind him. Yeah, and then you, sir. All right. Yeah, go ahead. Yeah, and then go ahead, and then it'll be the one in front of you.
Lovely to be back at UCL. Just on that theme, as somebody who's about to become an Irish citizen in 6 weeks' time, thanks to this result, a proud UCL law graduate, what is going to be the impact on the Ireland Act of 1948? As George rightly said, under the Thornbury case, that would be considered a constitutional act under Lord Justice Law's interpretation. But a lot of the ancillary rights, like the ability to apply for a British passport, for etc., are often interdependent on the Citizenship Directive of 2004. And how are they going to interplay for the 6 million people that are eligible to be Irish citizens going forward post-Brexit?
Okay, and now the gentleman 2 rows in front, also in the blue tie. Yep.
there was a referendum in 1975. If the vote had been otherwise, would these same questions have arisen, or can we learn anything from looking back at that referendum?
Thank you. And now the gentleman in brown, and then the man next to you.
Can you explain why you think Article 50 is a prerogative power when it's actually part of the Lisbon Treaty, which was incorporated into English law by the European Union Amendment Act 2008? Further to that, you claim that a new Act of Parliament will be needed to authorise Article 50, but would that not just be an exercise in duplication, since there's already an Act which gives statutory authorisation to the government to trigger Article 50?
Okay, and then the gentleman to you, that's it, yeah, go ahead.
I think it was Ronan who was making the argument that the EU authorities would be unlikely to look behind the credentials of the ministers who used Article 50 to notify of the intention to leave. I wonder whether that takes into account the explicit requirement, which is unusual in EU law, that the decision be made in accordance with the leaving member states' constitutional requirements, and what effect that phrase has if they won't look behind those credentials.
Okay, I'll just look over the other side of the room. There's a gentleman here in the front, and I think you're going to be the last, sir. Yeah, there's just here, this gentleman. Yep.
Hi. Earlier, it was mentioned two main models and the choice between border control and the free market. But I think there's a third element, and that's the contributions to the EU. Wouldn't that be like a third parameter that the UK could leverage in its negotiations? In other words, buy its way into a deal by increasing its contributions?
Okay. Look, I'm going to take one answer from each of the panel. I think the questions fall into two broad areas. There's the position of Ireland and the position of the Article 50 and the prerogative powers argument. And as I say, you each get one go to answer either or both of those, or to make any further point that you didn't make during the discussion. I'm going to start at that end and move towards this end. So I'm going to start with Ronan, and in particular, obviously, maybe the Ireland question.
Okay, thanks for interesting questions. I think the reading of Article 50, the first question, that the natural meaning is it's just there to protect the sovereignty of the member state, I wouldn't agree with that, because any member state can leave tomorrow. They can just, as a matter of domestic law, repeal all EU law, revoke their membership, and there's nothing the EU can do about it. I see Article 50, the 2-year period, it's there to provide a degree of protection for 2 years for member states, prevent them from being preemptively dumped out, but also to put pressure on them to conclude a deal. But
it would be a treaty breach just to leave.
It would be, but there's no need to protect national sovereignty, because we all know that if the UK leaves tomorrow, the UK Supreme Court is not going to defer to the Court of Justice saying that you shouldn't have done that. Parliament. In relation to Ireland, I think the big issue is Northern Ireland Republic movement. You already effectively need a passport to go between Ireland and the UK. There is precedent in the Nordic Union has some non-EU member states, and they have free travel between Iceland and people like that who are not in the EU. They are, however, all in Schengen, which is not the case for Ireland. Final thing, whether the EU would look behind the constitutional credentials of a notification, I think it's just unlikely, because if you can imagine a situation where notification is given, they carry out a year into negotiations, the Supreme Court rules that actually this should have been done by Act of Parliament, not by not by prerogative powers. I just can't imagine the Court of Justice of the European Union either engaging in its own analysis of UK constitutional law to verify whether the notification was given, and it would be very much in tension with the tradition in EU law and all the treaties that EU treaties are ratified by deposit of the instrument of ratification by the member state, and that it's the act of deposition that EU law is interested in. They're not really capable or interested in the internal constitutional dynamics. As long as there's any feasible case that the Prime Minister had the authority to give the notification, I think they'd stick with that.
Okay, thank you. Virginia, your turn.
Just big but quick general point that has been touched upon by other speakers, but also in a couple of questions of the audience. I want to say that it is, from the more I hear about it, both from my colleagues and the audience, the more troubling I find it that we had a referendum on an issue that has such implications of a constitutional human rights nature for the rights of very many people in the UK, both EU citizens and UK citizens living in the European Union. So I just find it very troubling, very problematic that we had a referendum on this issue.
Yeah, I think a lot of people agree with you. Not that I'm commenting, of course. Jeff, I beg your pardon, George.
Right, so on the question about the limits to the prerogative and what we can learn about the previous referendum in 1975, so it is a tired metaphor, to use the divorce metaphor about Brexit. So people have been using it, but it's a very apt one. And when you think about it, it's easier to commit at the start to a relationship than to leave. When you decide to leave, there are property issues, there are kids involved, there's all kinds of obligations you have. And therefore, how to exit a relationship should be more difficult than how to enter it. And that's why the referendum in 1975 was very different in nature. It was already in, the decision was made by the executive, and then there was a referendum confirming that. Whereas now we are looking at a referendum which will take us out of a long relationship with a vast effect on people's rights and liberties. And that cannot just happen overnight. It's not a plaster you pull out and then you make EU law disappear. So I think the influence of EU law within domestic law and the importance of Parliament and the courts being involved in this will last for a long while. And it is like Hotel California. I think the effect of EU law in this country, you can check out of the EU, but you can never leave because of rule of law values. So what I want to stress here is this, that no single referendum is a political event. Right? The legal effect of it will be determined in combination by courts and Parliament. And that's the only way that the rule of law will have it.
Okay, thank you. Jeff?
Thank you. I'd like to respond to the point which I believe was made by Carl Gardner, if I'm not mistaken.
Yeah, Carl Gardner.
About the ramifications for other treaty relationships. It has no ramifications for the UK's ability to enter other treaties, because the key thing about that act is it doesn't produce domestic legal consequences. We're in a different situation where you leave a treaty that Parliament has provided that will have domestic consequences. It's possible that there are other acts that incorporate international law where they can remain standing after withdrawal from the system. It's possible the Human Rights Act 1998 is like that. There are other international agreements, though. I think the European Communities Act is one example, where it has been so deeply incorporated into the fabric of a parliamentary statute that you cannot do that. And I think the Belfast Agreement is one such example. The Northern Ireland Act 1998 gives effect to the deal achieved in the Belfast Agreement. I think an executive act to withdraw from that agreement would fall on the same grounds that we've discussed here today. The second point was that I'd like to address. It was the fifth question about whether or not the right to leave the EU, to issue a notification, is governed by Article 50, is a right under Article 50. And the reason it bites, and has been illustrated by Adam Tucker very effectively on our blog, is that the European Communities Act under Section 2.2 allows the executive, through orders in council, to make provision for the exercise of any EU right by states. That's the argument. There have been objections to this line of argument by Mark Elliott, and I'll leave those here for the moment. I think what Tom and I think, might be agreed on, I can't quite say, is that if you were to try to use that section to withdraw the United Kingdom from the European Union, it would fly in the face of the central purpose of the statute. The Padfield case, a leading case in public law, says you cannot use discretion conferred under an act of Parliament to do something that cuts against the scheme of that act. This situation would be more Padfield than Padfield was.
Okay, Tom, do you agree?
Yes, I'm not expressing any personal opinions on legal matters today, given my involvement in some litigation, but I'll just pick up a couple of points which I think I can reply to on the basis of what we said in our blog. The first is the question about Article 50. Does this actually not provide a guillotine that's in the interests of member states, but does it in fact provide a neat little backdoor exit for a member state who wants to get out quickly to simply sidestep through? Well, maybe it does. I mean, it might also have that effect, but in the real world, no exiting state is going to want to commit suicide by leaving the EU with no withdrawal agreement in place. I mean, it would be economically catastrophic for any state to do that. And so, whatever the intention of the section is, the effect of it is, as we say in our blog, that when you trigger Article 50, the scales, the respective power positions of the exiting state and the remaining EU states is massively affected and tipped in favour of the remaining states. The second point that I just want to pick up on was this question about the prerogative, and somebody asked, well, is it the case that whenever Theresa May wants to do something that maybe cuts across a statutory power, like, I don't know, firing a nuclear weapon or something, that would be unlawful? Well, the example given is an extreme and unrealistic one. If you take a more mundane exercise of the prerogative, such as use by the police of some use of force, the reality is that it's a very simple position as a matter of our law. If the exercise of the prerogative by a public official would be contrary to the Human Rights Act, or contrary to any other act, or contrary to the right to life, yes, it would be unlawful. That is the simple position. And if you knew that public official was going to do that in advance before they did it, yes, you could go to court, and you could either get the court to stop them doing it, or you could get the court to say that if they do it, it's going to be unlawful. It's very simple as a matter of domestic law. Now, if you use an unrealistic example like Trident, then the reality of the position is that it's probably not unlawful for the exercise of the prerogative in such extreme circumstances under domestic law. I mean, for example, there have been attempts to say that the war in Iraq was unlawful, and the courts have said, well, no, it's not. It wasn't unlawful. It wasn't contrary to any domestic law. So that, I think, is the simple, straightforward answer to that question.
Okay, and thank you very much. And apart from anything else, there's no rush with the letters to the submarines, because you can't actually get them to the submarines because they're under the. Pete, your last word.
Can you do it through a notification to the European Council? No, probably not.
Send them a text.
No, I just wanted to pick up on 2 points. I think I disagree with Ronan on the question whether or not, from an EU perspective, there could be any kind of review on whether the decision to withdraw is in accordance with constitutional requirements. I mean, it is a treaty imperative, which in my view goes further than the sort of normal business of making EU law and policy. And it ties in my view, to the values for which the European Union stands, which are now clearly confirmed by the Lisbon Treaty: protection of fundamental rights, rule of law, democracy. I think it's perhaps not very realistic for the European Court of Justice even to be given a chance to actually look into this, but as a matter of positive law, it does seem to me that this is now also part of EU law. And I noted that I actually heard the chief of cabinet of Chancellor Merkel on BBC Radio 4 soon after the referendum saying that, referring to twice to the UK taking decisions and Parliament being involved. It seemed to be a German position. In fact, if he said it twice, I think thought about it, that there's a kind of expectation from other member states perhaps that Parliament should be involved. Lastly, on the idea of buying yourself to an agreement with increasing contributions, that would, of course, be a third main theme of the Leave campaign, which would be undercut. No 350 million to the NHS, but perhaps even more to the EU to have a favourable trade agreement. I don't know whether that is really in line with the finding of the referendum.
Okay, well, thank you. We overran very slightly. Professor Dame Hazel Genn is going to tell you what happens next.
Thanks very much, Joshua. I'm no constitutional lawyer, But it did occur to me when I was listening to Ronan talking about unconstitutional acts merely being rude, that we might reflect on whether if we'd had a written constitution, things might be slightly different at the moment. I don't often reflect on things like that, but really do at the moment. I think that the issues that we've been discussing this evening are absolutely critical both to our future and to our sense of tranquility as a nation, and that is part of the rule of law. I think those issues are actually really important, and the sense that we need to get some clarity on these issues is really imperative right now. I know that there's been a lot of discussion in the press, in the media, about the issues we've been discussing this evening, and I've listened to a lot, as I imagine have this audience. But I have heard things this evening that I hadn't reflected on before that raise important questions. There are no immediate answers to these things. The debates will continue, and I hope that UCL will continue to facilitate and to inform that debate going forward. So I would like, first of all, to thank the audience for coming this evening, to thank you for the questions. I'm sure that there could have been 100 other questions, but thank you for those who contributed. I would like you to join me in thanking Joshua for his very able facilitation. And whichever side of the argument you may be on, or which of the many sides of the argument you may be on, whether you agreed or you disagreed with the comments that were made by our panel, by my colleagues, I hope that you will agree with me that the quality of their commentary, the quality of thought that went into it was absolutely outstanding, and I hope that you will join me in thanking the panel for their contribution this evening.